Ma'am, you may begin.
Thank you, and welcome to the first of many National Practitioner Data Bank Guidebook presentations. We're pleased to partner in this presentation with the American Health Lawyers, and indeed it has been a partnership for us. We've been happy to our best, make this representative of what American Health Lawyers and the general membership might want in a webinar. Let me introduce you to those who are here in the room with me from the National Practitioner Data Bank as well as from AHLA. I'm Erna Hughes, the Director of the National Practitioner Data Bank. Joining me from NPDB are Judy Rogers, who is our Deputy Director, Laura Burns, who is the Branch Chief of our Policy and Disputes Branch, Elizabeth Lowry, who's a Policy Analyst. They in fact, are the presenters. There are other fine folks who are my colleagues here in the room, and as necessary, they may join in. We're also joined with Bill Burgess, who is from the Office of General Counsel at the Department of Health and Human Services. So part of your team members are here in the room with us, and that includes Michael Cassidy and Robert Harrison. I'd ask for them to share a few words with us. Michael Callahan will join that introduction as well. Thank you.
All right, thanks, Erna. And first of all, I want to thank Erna and her team of folks there. It's not often you get a government agency that is willing to create a program for, in this case, our AHLA members. They've been very open, very transparent, and very willing to receive comments. And because AHLA and other healthcare attorneys did present a number of comments during the comment period when the guidebook was in draft form, again, Erna offered to create this program. So this program is based on, I guess, what we're calling our top 10 hot button issues, which we identified as areas of additional questions, issues, some concerns, and those of you who have signed up for the program know that we sent out a link to the 10 issues that we identified. We just sent out a link that came out about another notice about 20 minutes ago where you can actually download the slides as well that will be followed by Erna and her team. We know at one point we had about 1,200 people that had hit the link. Don't know how many people actually were participating, but clearly this is a program of interest to our particular members. I'd like to introduce the co-chairs, Mike Cassidy, Robert Harrison, who are there with Erna and her team. Mike is a partner in the law firm of Tucker Ahrensberg in Pittsburgh. Mike was a former chair of MSCPR. I'm the current chair, and also was co-chair of our data bank work group. That particular work group prepared a member briefing of the data bank, about a 65-page summary of the new guidebook. So if you haven't already downloaded that, please do. It's an excellent resource. Mike's co-chair, who also is there today, Robert Harrison. Robert's with Kimball Legal out of Salt Lake City. Again, has been co-chairing our work group for the last 3 years or so. So thanks very much to them and the team of data bank work group members that helped prepare the member briefing. Also, I want to thank Robin Nagel. Robin, who is Vice Chair of Strategic Activities, was very much involved in the guidebook summary as well as preparing. Unfortunately, she had a conflict, was not able to participate. I am taking her place. So with that, I'll turn it back over to Erna.
Thank you so much. So I'll add a little bit of an additional frame to our discussion and do a bit of housekeeping, if you will, so that those joining us remotely can understand the flow of today's conversation and presentation. Firstly, it's important to underscore that the presentation today is meant to explain policies that are in the revised guidebook and, as Michael mentioned, respond to specific questions as raised by AHLA. Important to note that the revised guidebook, while it was some 13 years, I think, in the making, the relevance of that has to do with the fact that it combined guidance related to the NPDB, the HIPDB, as well as added language relative to Section 1921. It did not introduce new policy that required regulatory or statutory change. So important to keep that in mind as we move forward in the substance of our discussion. Housekeeping matters in terms of how the conversation will flow. We have quite a bit, a very packed agenda. And so with that in mind, we're going to keep a tight ship. So the time frame in terms of each of our presentations will be monitored quite closely. In order to facilitate the discussion, we broke the areas of topics into 3 sections that had some commonality to them as a way, again, to keep the conversation flowing. At the end of each section, Mr. Harrison and Mr. Cassidy will, if time permitting, will ask additional questions or further the discussion. Because of the large volume of listeners, we're handling your questions a bit differently. You'll see a box on your screen that reads, "Submit a question." You may submit a question here at any time. Your question will not be seen by the audience, however. Only we here at the data bank will observe your question and have an opportunity to respond to it. We'll gather your questions, prepare a response that is available to the whole group. If you are interested in one-on-one guidance, that's actually something that we're quite interested in providing to you, and so that's actually our day job. So if you have something very specific and nuanced, we're happy to follow up with you post this presentation. Again, because of the time, we can't take your questions in real time, but indeed are very intentional in our desire to follow up with you. If you'd like to submit a question via email, you may do so at npdbpolicy@hrsa.gov. Finally, if you have difficulty hearing us or you need us to slow down, in fact, if our audio is a bit ineffective, please use the icons on the top left corner of your screen. You can indicate any challenge you might be having with the audio portion of this. So with that, I'd like to turn the conversation over to the substance and ask my colleague Laura Burns to begin.
Okay, thank you, Erna. And this is Laura Burns. I'm the branch chief of the Policy and Disputes branch. And please let me know if you are having volume difficulties. I know I can kind of be a low talker, so I'll try to accommodate for that. So we'll go ahead and get started. All right, so our overview. As Erna kind of said, we are on a tight time frame, so we kind of put these questions, the top 10, into different sections, and we'll go over a few of them and then leave time for questions and answers. So the first few are the ones that I will go over, investigations and various points related to investigations, such as leave of absence while under investigation, informing practitioners while under investigation, and proctoring. And before we get into your specific questions about investigations, there's just a few points we wanted to kind of go over. The first thing is to say that we understand your concerns. We got several comments in the draft guidebook, and we do understand where the medical community is coming from. This is not an expansion of our old policy, and we hope that as we go through these points today, we will show that to you. So as we say in the guidebook, the bylaws and the hospital documents are used to determine if an investigation has occurred. We expect to defer to hospitals on this. Largely, we expect that hospitals will apply the logic of our guidelines to determine for themselves if an investigation has occurred. And the statement that the NPDB retains the right to be the ultimate arbiter is really to respond to the fact that different hospitals may have different processes in place and different ways of approaching investigations. This flexibility is there for industry standards. So getting right into the questions. The first part of your first question, there are 3 different parts that we'll kind of go over. When does a routine peer review end and an investigation begin for purposes of reporting a resignation or withdrawal while under investigation? So you see on our slide here, we have kind of our major concerns or our major factors to consider. Is this focused on a particular practitioner? Does the inquiry concern the professional competence or conduct of the practitioner in question? Is there a specific competency or conduct concern? It might be beyond your routine review where you're in the OPPE stage looking to see if there are any sort of substandard care concerns generally, and the FPPE might raise to another level of routine review, but this might be an inquiry might be even more specific to a very specific competence or conduct concern. And generally this last element here we'll go into a little bit should generally be the precursor to a professional review action. So a few things for how you might determine that. You could look at your bylaws, you look at your documentation, look at your practice standards. One of the articles, you all provided us with a lot of good summaries and information and documents. One of the articles talks about, I think it was, when does an investigation begin? It talks about FPPEs rarely lead to professional review actions. That's the type of logic that we would take from a hospital in assessing whether or not an investigation has occurred, and we would probably agree with. So you could also look to, if you're looking to see if it's a precursor to professional review action, you could look at the language of the performance agreement itself. Does it say anything about future disciplinary actions? Does it say, X, Y, and Z could happen, and then this is where it could lead? That would indicate maybe where it's going, whether or not it's a precursor. So specifically to the part A of this question, you ask, for example, let's say a hospital tracks post-op infections for all surgeons in the Department of Surgery as part of its OPPE standards, but also its FPPE plan for new surgeons. Dr. Callahan is a new surgeon. Within the first 6 months while the FPPE is in place, Callahan has 3 post-op infections, which is higher than the average. As a result, the FPPE is extended for another 3 months. Is he now under investigation? So the answer that we have for that might not be all that satisfying, but I think that lawyers should respect is it depends. And when we look at a circumstance, what the hospital would consider is the fact that the FPPE is FPPEE, I've been practicing that all weekend, is standard practice that signals that it's routine for sure. But the extension appears to be a deviation from that routine, and that signals that it could be an investigation. Is it extended because of a competency concern, which is different, in this case it appears to be, and that would be different than, let's say the FPPE said you need to complete X number of procedures in this amount of time, and that wasn't done. That might extend your FPPE, but that extension might not be an investigation because you're not looking further into that competency concern. And generally we did remove the language from the guidebook about FPPEs and OPPEs to be less prescriptive. However, we don't want to draw that bright line and say that FPPE would never be the beginning of an investigation. If you consider these considerations, we think that there could be a time when an FPPE could be one. So getting an indication from my timekeeper. So let's see, move on to the second part of question 1. What if Callahan has been on staff for 10 years and has 3 post-op infections in 6 months, and a decision is made by the Department of Surgery to do a concurrent review of his cases for the next 3 months? Callahan is not aware of this review because his clinical privileges are unaffected. During the 3-month period, he resigns because he is on 3 other medical staff, which make it difficult to provide ER coverage for all 4 hospitals. Is he under investigation during this 3-month period, and is his resignation reportable? So if the hospital considers this routine and not an investigation, then it would not be reportable. However, if the hospital considers this an investigation, then I think you all know this point, but the fact that he does not know or that he left for other reasons don't matter. And if it is considered an investigation, then his resignation would be reportable. So just kind of looking again at this example, is this concurrent review the type of thing that leads to professional review action? Another way to answer that question, maybe you can't predict where something is going at the onset of the investigation, but you have enough information to kind of say what type of concern this is. Is it egregious? Is it potentially very serious? Or what sort of investigation could follow based on your experience, based on with this experience with the information that you have on hand. There was, actually, we're still on. We're okay for that. So one additional point here, Al Edelman provided an article to NAM, and we did look at some of those, and we're actually in the process of responding to those as well. But one of the questions there is about whether a physician applying for reappointment puts on their application they have 3 medical malpractice claims in the past 2 years. That then signals additional review. Is that additional review an investigation? And the reason I bring this up is because I think it's a good example of how you might distinguish between a focus inquiry and a specific concern and differentiate it from a standard routine review. So if you have a process where for all renewals, the checkbox under medical malpractice comes up that let's say 3 cases have come through in the past 2 years, maybe there's a number standard. Every time you get 2 or 3 cases, you automatically refer it for additional questions. That might still be routine. You might not consider that an actual investigation. However, if you were to look at something that came up in those medical malpractice payments that said very specifically this is a concern, then maybe you're looking at the start of an investigation. So that's just an example, not to be prescriptive, but an example of where routine deviates from specific concerns. Okay. Now we actually are on this slide. Just to kind of sum up, we talked about what the beginning of an inquiry could look like. The end of an investigation does not end until the entity makes a final action or formally closes it. And so bring this point up because the use of our word expansive in the guidebook, I think brought some comments. And really, we use that word to indicate that an investigation does not end just because someone resigns, or does not end in the middle. It extends all the way until the decision-making body has taken a final action or formally closes it. And then again, just to restate, we retain the authority to be the ultimate arbiter, but we do largely expect to defer to hospitals and using our guidelines, applying to what the standards that you have in the bylaws and documents to make those decisions. Okay. We are now moving on to a specific question about leave of absence while under investigation. So generally this slide, we kind of go into our generic rule about resigning while under investigation. The reports are not required for investigations. I think everyone knows that, but every now and then I think that gets a little lost. The investigation itself is only important for determining if a reportable event has happened. Reports are required for resignations while under investigation, and that's the resignation of privileges, even if the investigation later reveals no fault with the practitioner's professional competence. And a revision to action report is optional. So with your specific question, it relates to question 21 in our guidebook on page E46. And that specific question, there's a situation in which a physician takes a leave of absence for personal reasons and is reported for resignation while under investigation. Found this troubling and confusing, and you question whether taking a leave of absence constitutes a resignation for reporting purposes. Secondly, it was unclear from the question what type of investigation was being conducted and whether it was related to any competence or quality of care. And third, based on the scenario, it appears that the revision to action report would be required, not optional. So, starting kind of at the first point, as long as the leave of absence restricts the privileges, then yes, it's reportable. And I think you guys have in another one of your written documents, there's a scenario where a leave of absence does not affect privileges. The privileges are not surrendered. And if that's the case, and a hospital has that and privileges are unaffected, then the leave of absence is not reportable as an employment or action. It is only reportable if it does have a limitation to your privileges. However, the language in the regulations is that the surrender of clinical privileges or any restriction of such privileges is reportable while under investigation or to avoid investigation. With that being said, if a leave of absence affects your clinical privileges, then that is reportable. Whatever time period of the restriction, whatever duration, for whatever the restriction is, even if it's a restriction to just not practice certain things while under investigation, that is also reportable. And to the point that the question is unclear about whether or not the investigation was related to competency or quality of care, that, we did look at that again, and we are open to that suggestion and making sure that that language is clear that it was for that reason. And then third part, why is it an optional revision to action? That's because it's not actually imposed. This isn't something imposed by the hospital. It's not something that came on the end of a professional review activity. It was self-imposed. You resign your privileges. That's something you do yourself while under investigation, and because of that, it's optional to revise it. Now we're going to look at the rule about informing practitioners while under investigation. Practitioners, and we have two different rules here, one for state licensing boards and one for hospitals, and we want to put those up side by side because that's really why, when you ask us why we take this position. Practitioners must be informed about an investigation before an action is taken by a state licensing board. However, practitioners do not need to be informed about an investigation before an action is taken that could result in adverse privileging action. Your question specifically was explain why the NPDB takes an inconsistent position in stating that, with regard to hospital privileging, a matter is reportable while under investigation, even if the practitioner does not know there is an investigation pending when he or she resigns. Whereas, with regard to a government-issued license or certification, the government entity must be able to show that the licensee was aware of the investigation prior to reporting a surrender or withdrawal of application for renewal while under investigation. So your question is this not inherently unfair to the person to resign without knowing he is under investigation and yet still receives an adverse NPDB report? In light of DPDB's position, at a minimum, shouldn't the guidebook give a strong recommendation that physicians be notified anytime an investigation could trigger reporting? Basically, this boils down to the regulations. And the regulations include, in the definition of voluntary surrender, which is under our licensure requirements, that the practitioner be given notice. To the point that in your question you say that the practitioner must be aware of the investigation, it's actually not. You have to provide notice. Whether or not the practitioner knew that the investigation was going on is not required for reporting, again, under licensure actions. Now your question specifically to clinical privileges, it's not in the regulations this way. It's not provided. It's not required. And our practice has been to not get involved in how hospitals impose due process and how they carry those elements out. We've found that there might be legitimate reasons for not informing a practitioner at the onset of an investigation. And in particular, I think there was one other point I wanted to make. Oh, we've actually found that this is the problem with notice is more frequently happens in licensure, that we have complaints of not being noticed. In hospital settings, we don't find that's been our experience, that we don't find an issue with notice, that practitioners are notified. To the extent that your experience is different, and to the extent that you have stories or information about how notice is not being handled, we certainly are happy to hear from the field, what's really going on there. Sorry, went too far ahead. Okay, proctoring. This is the final part of this section, and then we have Q's and A's from our attendees in the room. So finally, for proctoring question, there's a couple different elements of this that we went over. Is a proctor, your specific question, I'll just go into the details of it. Please discuss the parameters of reporting a restriction of privileges, for example, in the context of a practitioner who's being proctored for 45 days by a physician in the room who is scrubbed in but merely there to observe, not to intervene. Assume the 45-day time period was the amount of time that the hospital expected the practitioner to admit and treat approximately 10 patients, which is the standard number of patients when proctoring is imposed. If this practitioner admits 10 patients in 30 days, the proctoring requirement will be lifted. If this is standard operating procedure, including a requirement to personally observe, is this reportable? So the first couple things before you get into the days and the time period, if that matters, the 45 days versus 30. First, is proctoring the result of a professional review activity? Is it a professional review action? Was it put in place to course correct or to respond to an inquiry or professional review activity that had concerns about the competence of a practitioner? You're only reporting proctoring if it's the result of a professional review activity. So the second part of that is, the second question you need to answer before you kind of look at the day period time frame is, can the practitioner admit a patient without the proctor observing? In other words, it's 45 days because that's typically how long it takes to admit 10 patients, but is it the next 10 patients? Is it 10 patients over 45 days, but in the interim you could admit patients without a proctor present? The question, can you go forward with this procedure, with this hospital admission without a proctor, would determine whether or not it's reportable as well. And then if it is, if you find that the proctor has to be present for all 10 observed admissions, and the practitioner completes that requirement within 30 days, then you haven't met the reporting requirement that it meets that is over 30 days, and it's not reportable. So if that sounded a little convoluted, but the first couple things you're looking at, is this the result of a professional review activity, and is this something that the practitioner cannot go forward with the procedure or the admission into the hospital without a proctor? If those two things, are true, then you would look at the day period and the time frame. And if they completed it within 30 days, then it would not be reportable because it would not meet that requirement. And the second part of this question, a related question, is whether a physician who is being monitored or proctored is under investigation during this period of time. If yes, does that not create a logical inconsistency? The resignation under these circumstances is reportable even if the action they have taken is not, and even if the so-called investigation from the hospital and medical staff standpoint was never going to lead to a recommended action, such as a suspension or termination, which would be reportable. So proctoring could be considered an investigation if its focus is to collect additional information. However, you kind of answer your own question here as to whether or not proctoring is an investigation in this situation. If proctoring is not the type of activity that generally leads to professional review action, then it probably wouldn't be considered the beginning of an investigation. But because of the potential information gathering nature of proctoring, if a hospital implements a practice where proctoring is a precursor to professional review action, then we could see it as being the beginning of an investigation. And I think I have ended a little early, so we have time for questions.
Well, that's terrific. This is Mike Cassidy, and speaking on behalf of the AHLA, we really appreciate all the help. As Michael Callan has already said, the involvement that you've given us since the first presentation of the draft of the guidebook. The issue of investigations and, when they start and does start and generates reporting obligations may be the hottest of our hot buttons. And it is not because some people perceive that hospitals and physicians want to be able to take peer review actions and avoid the reporting and due process requirements. It is more because the addition of making an investigation in the invocation of the due process rights provided by the Healthcare Quality Improvement Act simply so dramatically change the nature of peer review once it starts that it's no longer quality improvement, it becomes litigation. It doesn't give the hospitals or the physicians the opportunity to engage in the quality improvement. They're too affixed to the idea of what do we have to do to protect everybody's rights here. And when you say that the hospital, you can defer to the hospital in doing this, would you take that as far as to say if the hospital defines, we will tell you when our investigation starts. Our investigation starts here. Everything we do up until the time where we've decided that the investigation starts is our version of quality improvement, of normal peer review. And it makes it a lot easier now that FPPE hasn't been defined as, as de facto investigation. It gives the hospital and medical staff bylaws the opportunity to do that. You'll let them decide when it ends, or you'll let them decide when it begins.
So I think, we will reserve that right, and I can give kind of an example of when we might, but we looked at, one of the pieces of literature that we looked at was that article on when an investigation begins, and there were several sort of examples of defining the beginning of an investigation and defining it by the referral to the MEC, and we all thought they were very reasonably drawn out, as this makes sense that this would be the beginning of an investigation. So for looking through that article, there was this one point where it said, an FPPE doesn't typically go to professional review action. It might go to a PIP. It might, then be referred to the MEC or then be referred to the board. So while all that compared against your logical, how you define it in your bylaws and your documentation, if you define it this way and compare it against standards of practice, it makes sense. Then, yeah, we would defer. But if you're looking at something like this is your OPPE is not focused, and your FPPE focuses, and your PIP focuses, and maybe there's something else, and then your bylaws say you start at the referral to the MEC, yet when we're looking at that case, we can see there's a focused inquiry about 4 times prior. That might give us pause, whether or not we would come to the conclusion that that investigation should start prior. That I can't say, but I think that, yes, we would give the hospitals the opportunity to write into their bylaws and document how they define an investigation, and if it makes logical sense and looks good with our guidelines, we are okay with that. But we will retain that discretion if it seems that there's been an inquiry, several places prior.
Great. Thank you.
I have just really sort of a couple of follow-ups under that general umbrella. The first is the point about leave of absence. I think one of the things that has led to some struggle with our members on this is that it seems to be, if not commingled with, at least treated the same as a resignation. And that's something that I don't think any of us really who practice in this area have ever considered a leave of absence to be a resignation. They're 2 very different things. Just a couple of examples of ways in which they are different. A resignation terminates your membership in the medical staff. A leave of absence does not. Resignation requires you to reapply if you ever want to come back. A leave of absence does not, except in a situation in which you had a lengthy leave of absence, which subsequently caused you to exceed your 2-year recredentialing cycle. If you didn't do anything about it, that would be treated as a resignation, but that would be the only circumstance in which someone on a leave of absence wouldn't be free to come back totally whenever they wanted to. Another thing is that resignation terminates all of your procedural rights and protections under the bylaws, whereas a leave of absence does not. But perhaps most importantly, the resignation in almost all cases will stop the investigation. That's the end of it. With a leave of absence, at least in my experience, I've never known a leave of absence to stop an investigation, because that individual is still someone who's part of the medical staff, and the hospital is concerned about identifying issues that might be there. And this is really, it dovetails a little bit into the second point, which is whether the practitioner knows about it or doesn't know about it. But there are lots of situations where people take a leave of absence for reasons that have absolutely nothing to do with anything about their privileges in the hospital. and they don't intend to leave the community. They do intend to come back to the hospital. Sometimes they're ill. Sometimes it's a sabbatical to get some training somewhere. Those folks will, on occasion, actually still be there in the neighborhood. They will still be participating in good faith with an investigation. They may still be coming into the hospital to attend grand rounds, doing a variety of things. And so the concern is that that here's someone who's not trying to avoid or manipulate anything. They are an active part of the process there and feel that they are still fully committed to whatever's going on in the hospital. For better or worse, there is, and we may as well, nobody's mentioned this yet, but I will, the perception is out there that a data bank report is a very negative, damaging, even punitive thing. Whether that's correct or not is a different discussion for a different time. But it's a perception that I think we all acknowledge. And so the reaction of practitioners to the idea that if they take a leave of absence for some reason and there happens to be an investigation, then they're going to get what's perceived as a black mark, it's a fairly strong reaction. And I think that's important, and I hope that we can continue to talk about this, because the end goal, the policy goal of everything that's here before us is to have more peer review, because we all believe that improves quality. And anything that we can do to help people be more comfortable with having more peer review is, I think, going to lead to more of it being done. And so with that in mind, I hope that we can continue to talk about this, and if any of you have ways that we can help reconcile this a little bit, reconciling the idea of treating something that's clearly not a resignation as if it were a resignation, that would be helpful to us. And I'll move on quickly. The timekeeper has not frowned at me yet, but I expect he will in just a minute.
Would you like a comment on that?
Oh, I'd love one.
Okay.
Thank you.
Definitely, we would be interested in kind of seeing your documents where you've defined them differently and sort of the hospital support for that. That would be very helpful for us. And I think that the distinction that you've made is well taken, and to the extent that our regulations say a surrender or restriction of, and I think that's where the leave of absence, to the extent that it does restrict privileges, and it sounds like maybe it doesn't, but to the extent that a leave of absence does restrict privileges, that is reportable under our regulations. So I think that we'd be happy to look at those documents and see, if it's not restricting privileges, then maybe we treat it differently.
The almost parallel point is the idea of reporting individuals who are under investigation when they resign but are unaware of the investigation. And we talked already about the inconsistency between the requirement for state agencies and the requirement for hospitals. And I think you've spoken to that nicely. What I'd like to raise, though, is an inconsistency between what to us seems to be a new position at the data bank about reporting individuals who resign while under investigation. And again, I'm speaking from my experience, not necessarily for everyone who's on the phone, but I do think this is fairly representative of what our experiences have been in the industry. Our understanding has been that the policy goal which animates this particular reporting requirement has been to address practitioners who want to manipulate or completely avoid the reporting and flagging system by resigning to either stop or avoid even getting started with an investigation that they don't think is going to go well for them. And we all know that that's been a problem. And our understanding was that that's what this was intended to address. And so that meant that what would be reportable would be this attempted manipulation, this resigning to avoid that investigation or to avoid the conclusion of that investigation once you've been notified about it. And that understanding, it's consistent with what the data bank had said in 2001, the 2001 guidebook at E34, and I'll quote this. It says, "To be reportable, a practitioner's resignation must be tendered in order to prevent a professional review action, close quote. And that's consistent with the idea that we've always had, that if you know you're being investigated and you resign, then that's a concern. And the data bank's comments in the 2001 guidebook are consistent with that. That is, they are consistent with the idea that if you have to tender it in order to prevent the action, well, you'd have to know about it. And so if you don't know about it, it hasn't been tendered to prevent the investigation, and therefore it's not reportable. And so if there is something that that you could add that will help us in 5 minutes. We're having some questions here about minutes and seconds. If there's something that you could add that would help us be able to reconcile that for our clients, that would be really helpful.
I don't have anything to add specifically, but we hear what you're saying, and I think that this is something that we can look at.
Okay, thank you.
And I guess I would toss into, in seeing some of these dispute resolution cases, that sometimes the question of whether notice has been given can be a question. There are some cases where it's been claimed that the person was told about the investigation from their department chair or by the medical executive committee, but there wasn't necessarily a piece of paper that was sent to them that said the investigation began. And the accusation in those cases was, well, the physician heard about it, they had notice about it, but they're claiming that they didn't have notice about it, so they can leave without having any ramifications. So that's one piece to it. I wouldn't say that that's the only reason why it's there and how they've interpreted it that way. And I guess I would also throw in that while it's maybe for the first time clearly in the guidebook, the position that knowledge isn't a precursor to a report for resignation while underneath investigation, it has been, I would say, the consistent policy of the data bank through dispute resolution, and I believe actually taken that position in a couple of cases, that the knowledge is not required, at least as far as the hospital privilege.
If we have just a few minutes, I'll put this in the form of a statement rather than a question to see if I can make it quick. You mentioned that proctoring may or may not be part of an investigation. So I think, are we comfortable assuming then that proctoring will not be interpreted as evidence of an investigation unless the other facts and circumstances indicated it is? The fact that somebody's being proctored won't make it an investigation without further action.
Right. In and of itself, proctoring is not synonymous with investigation, but certainly there are elements of proctoring that seems to be the same as investigation if it is information gathering and to observe and to consider future actions.
Good, thank you.
Okay, so now we're going to move on to what should be slide 8 if you are viewing slides. This is in response to the question, explain why, for a multi-hospital health system, there is a single credentials verification office, but where each hospital conducts its own separate credentialing review process, the health system cannot share the NPDB report between the hospitals, even with physician consent. Does that not lead to inefficiency and increased costs in the credentialing process? So the current process is, as we said, that hospitals that maintain separate medical staff credentialing and that they have to have separate registrations and accounts for querying for each credentialing body. Results can't be shared between separate account holders. However, if the peer review process is centralized and the institutions have a single decision-making body, then the hospitals can have a single account and share the query results. The data bank is designed in this way in order to maintain the integrity of the data that we provide out to queryers. The data bank is responsible for ensuring that the most up-to-date information is provided to registered entities who query. This means that if an entity queries the data bank and receives a report, and then later there's any sort of correction or revision to action, the NPDB can provide this new information to all the registered queryers who received the initial report. And if the hospital were to share that initial report with others, the NPDB would have no way to verify that all those who received that initial report also received any of these updates or corrective actions. Practitioners are allowed to share reports in which they're the subject. In those cases, we are aware that the data bank doesn't have the ability to update any of those entities that the practitioner might have shared the report with. But as we stated, data bank reports are often seen as something of a negative. So granting an individual the ability to share potentially negative information about themselves is very different from the data bank allowing entities to share potentially negative information about subjects with others, without having that ability to then correct any potential misinformation or provide the updates with revisions to actions and that sort of thing. At the data bank, we are always open to suggestions and ideas for improving our operations to better serve all of our constituents. So while we can't promise that every suggestion would be implemented, we are happy to receive them. Again, the address that Erna provided at the introduction, the NPDB policy at HRSA.gov, certainly a good place to send in your thoughts and suggestions. Now we will go on to slide 9. So the question that this one is addressing, the guidebook states that when an action, such as a summary suspension, is overturned on appeal, all queriers who previously were notified of the summary suspension will receive a void report and then must destroy the prior summary suspension NPDB report. Does that not place at legal risk those queriers who may have acted in good faith reliance on the earlier summary suspension report? Does the division have the authority to require other queriers to destroy valid summary suspension reports previously received from the data bank? And has the division considered the potential legal risk or litigation exposure to queriers who have relied and acted on such data bank reports in good faith? So the data bank always sends a report void confirmation to the reporting entity once a void is processed. The system also sends a notification to the subject of the report and to all queriers who received the previous version of the report within the past 3 years. That notification does instruct all queriers to destroy any copies of the prior report. This policy is an attempt to balance an entity's need for information with the practitioner's confidentiality. And since a voided report is meant to be the same as a report that never occurred, we feel that it would be unfair to practitioners to have copies of those prior reports remaining after the void is processed. To clarify, the requirement to destroy reports is actually not new guidance. While this is the first time the instructions have been included in the guidebook, they've actually been included on all void notices since at least 2007. We believe it's probably even earlier than that. And it was always the intent since the beginning of the data bank that prior reports would be destroyed once a void report was issued. Again, we're not aware of any issues that hospitals have had with liability in these cases. But if you do have real-life examples where this has posed a problem, we're happy to hear about them and then consider potential changes in future guidebooks. So that section went pretty quickly, but if you do have any Q&A, try and address them.
Yeah, we do, but I think you want to go first.
Sure. Just a quick, really perhaps as much of a comment as a question about the sharing. It may be that our systems are viewing, I don't want to say terminology exactly, but viewing what they do in a manner that's not exactly the way the data bank is viewing it. The query is part of the initial credentialing process done, and hypothetically we're talking about a system in which there's one central credentialing office that processes all of the application materials up front for X number of hospitals in the system. And only when that application is complete, when that process is finished, only then does that packet go out to the individual hospitals where they will use potentially differing processes for deciding whether to give particular privileges to that provider. So it's really a two-part process. The query is part of that initial process. And so we look at it as something that is shared, is identical for all of the players. There's no difference whatsoever in how any hospital obtains or reviews that query information. And I was struggling with this a little bit when you were talking about the need to maintain the identity, or I'm sorry, the integrity of the, we know who you are.
Yeah.
The need to maintain the integrity of the data bank and a concern about sharing information with others. I think the question really that we keep coming back to is, when you say others, we're not sure who that is. If it's people who are outside of the system, then that makes perfect sense. But because that central credentialing function is doing it for everybody, there aren't any others. So when the question comes up, look, we've obtained for our system a query, and we'd like to send that out to the hospitals in the system when we send out the package. We don't duplicate everything else. There's one packet of information that goes out. So it really isn't going out to others anywhere else. And so perhaps to the extent that that I do have a question, it would be to maybe have some further conversation about that. And then just to mention that duplicating the query is inefficient and expensive for hospitals to do this, and they're struggling with, why do I need to do it and do it and do it when everybody sees it and it's only one package and then it goes out to everybody? So that's really where we are. Thank you.
Oh, certainly, and perhaps it is something that we can get together and make sure we're talking about terminology and using all of these words in the same way and to mean the same thing. So, certainly.
Okay, I have a question about the destruction of voided reports. Our concern is that some hospitals may prefer to maintain their records for a future defense. I mean, the language of the guidebook actually says queriers who receive queriers, not necessarily the actor, that received the previous version of the report are advised to destroy the report. I mean, there's nothing in the regulations that indicates that they must destroy it. The language itself doesn't make it mandatory. It says they're advised to do that. And there's also this kind of the same rationale that applies to the confidentiality of the reports. The data bank confidentiality language says that people aren't allowed to release that information, but it's not talked about in terms of the physician. No, it's not telling the physician that if he has a copy of the report, that he can't give it to somebody. In fact, many employers who aren't entitled to query require the physician to query and disclose the report. So perhaps under the language, maybe that would be illegal. Maybe the physician could say, I'm sorry, I can't do that. I'm not allowed to disclose that information. But how do you reconcile your position with the language of the data bank that simply says that they're advised to destroy it? And do you have any comment about this confidentiality issue that says that people aren't allowed to share this, but the doctors seem to be routinely allowed to share it? Or maybe you just want to take that back and think about it.
Yes, I think there is some simplicity here, and Bill was about to talk, so I probably shouldn't.
It was a signal to wait.
No.
So it's my report. I can share my report as the person who's been. That's pretty simple and straightforward. Maybe we're going to think to the rest of the question.
Right. Yeah. You are right. I certainly agree that as far as destroying voided reports, it's not something that's directly addressed in the statute or the regulations. So if someone didn't do it, I don't know what exactly would happen, quite frankly, if we would do anything. But and as far as the physician being able to give out copies of their own report and whether that's inconsistent, to a certain extent, as far as destroying copies of reports, I think it's meant as kind of a safety to physicians. So to the extent that they are disclosing their report, if that report is voided, then I think it kind of goes back to the physician, and they're incentivized to make certain that anyone who they have given a copy to that report to go back and let them know that it has been voided.
Good. Thank you. That's helpful. Very helpful. I don't have any comments on this section. We're okay for time?
Yes. Great. Shocking, but great.
Okay. Next, we're up to slide 10. This is Judy Rogers. I feel like we need a 7th inning stretch. Long time to think about data bank. We'll forge ahead. So slide 10 is about medical malpractice claims, and in particular, it addresses question number 6 in the questions that AHLA submitted to us. So in question number 6, you ask us to explain the guidebook statement that written claims or complaints include any form of writing. You went on to suggest that this introduces ambiguity and potential legal exposure for medical malpractice reporters, particularly given that the NPDB has stated that it is the ultimate arbiter of whether there was a written claim. So a couple things here. First, this is, again, not a change in policy. This is how we have consistently interpreted this policy around a written claim. And secondly, we believe that our regulations support this interpretation by defining a medical malpractice action or claim as a, quote, written complaint or claim demanding payment based on a healthcare practitioner's provision of or failure to provide healthcare services, and includes the filing of a cause of action based on the law of tort brought in a state or federal court or other adjudicative body. And then finally, if anything, we actually think this clears up ambiguity by being pretty straightforward that it is any form of writing, and as opposed to us trying to define what that form of writing might be. So to summarize then, you'll see on slide 10, just to make a couple key points, that reportable medical malpractice claims must be in writing demanding monetary payment for damages. This can include pre-litigation written communications. And finally, the NPDB determines whether a claim has occurred. Now, although we said it states in this slide that the NPDB determines whether a written claim has occurred, we generally expect reporters to make these determinations. Okay, on to our next topic, slide 11. So this slide is all about settlements and other adjudicated actions. And this slide relates to question 7 as submitted by the AHLA. Question 7 asks us to explain the DPDB's approach or interpretation to the state reporting obligation related to other adjudicated actions or decisions. In particular, you ask us to explain our position that while settlements including no liability are statutorily excluded from reporting, quote, actions that occur in conjunction with settlements in which no findings of liability have been made, unquote, should be reported. AHLA suggested that this approach potentially undermines the purposes of the statutory carve-out and could potentially chill settlement negotiations. So here our idea generally is that if you take a reportable action along with a settlement, that action is still reportable even if the settlement is not reportable. We take it from the question that was posed that in order to encourage fruitful negotiations, the AHLA believes it would be preferable to state that the settlement should be excluded from being reported as well as the action that occurred in conjunction with the settlement. Again, this is not a new requirement. The concept of reporting actions in conjunction with settlements has been in the HIPDB regulations and now in the combined regulations since the beginning of the HIPDB. You commented that this undermines the statutory carve-out. We believe that the purpose of the statutory carve-out was to explicitly state that settlements are not reportable, but it was not intended to negate the reportability of an action taken in conjunction with the settlement. As to your statement that it might chill negotiations, we're not saying that's incorrect, but we've actually not received that complaint or comment before, so we're open to listening to that, and happy to hear more about that if indeed that's the effect that this requirement has. So then to summarize again from on the slide, settlements in which no findings of admission or liability have been made are not reportable. Actions that occur in conjunction with settlements in which no findings or admissions of liability have been made but that meet other NPDB reporting requirements must be reported. Okay. Now we'll move on to slide 12. So in slide 12, it's question 9 of the questions you've submitted to us, you very appropriately noted confusion between the terms professional review action, which triggers reporting obligations, and professional review activity, which does not trigger reporting obligation. And so you went on in your question to say that these are confusing terms in terms of identifying whether an event is reportable or not. The example you cited was when an employed physician who has been disruptive is required to meet with the medical staff committee or department chair as part of the collegial intervention process, is told that his behavior needs to improve. No action is taken regarding his membership or privileges, and he is not considered to be under investigation. A month later, he is terminated without cause and is not given a hearing or any other meeting. Did a professional review action take place? If so, what, and if not, why not? Was the termination reportable? If so, why, and if not, why not? Does the hospital have the discretion of determining when a professional review action has taken place? So for starters, we acknowledge that this is confusing, and it's not our fault. It's confusing because the Congress, this is language taken directly from our statute, so the Congress used one term to define another term, and it's always been a little bit of a challenge for us as well. So let's just go through it a little bit. If you look at the slide, you can see this is again, no, we're still on slide 12. So the statute says that in terms of a professional review activity, that it's an activity of a healthcare entity with respect to an individual healthcare practitioner to determine whether the practitioner may have clinical privileges with respect to membership, or membership in the entity, to determine the scope or conditions of such privileges or membership, or to change or modify such privileges or membership. Now, if we go on to slide 13, we get into a professional review action. So here's where one term is used to define another. Our statute says that a professional review action is an action or recommendation of a healthcare entity taken in the course of a professional review activity based on professional competence or professional conduct which affects or could affect adversely the health or welfare of patients, and finally, which adversely affects or may adversely affect the clinical privileges or membership in a professional society of the healthcare practitioner. So now, in answer to your question regarding the physician who was terminated without cause and had no hearing, if no action is taken against his privileges, that is, if the professional review activity was closed and nothing came of it, then it would appear to us that the termination is not reportable because it's not the result of a professional review activity and not a professional review action. You asked a related question, question 10, in your questions you submitted to us. You asked, when does a non-reportable administrative action become a reportable professional review action? For instance, if a hospital has an automatic suspension for failure to complete medical records, are there any circumstances under which the NPDB would consider this as a reportable professional review action as opposed to a non-reportable administrative action? Can the hospital define for itself these terms? Our response to this is that generally we let the hospital define whether there is a professional review action. We give discretion to the hospitals. The key word in the scenario you described is automatic. The question references the fact that there was an automatic suspension for failure to complete medical records. So again, the key word in the scenario is automatic, meaning in our minds that it's not likely to be the result of a professional review activity. And again, if not the result of a professional review activity, then it's not considered a professional review action. However, if there is any additional ambiguity because the failure to complete medical records is so egregious as to potentially affect patient safety, then it may be reportable. But it would still have to go beyond the automated system and into a review of the practitioner's behavior, which then results in a decision-making body deciding to suspend. We could flip to slide 14, which I believe is our last slide, actually. Related to all of this, wanted to just point out essentially what is excluded in definition of professional review action. Professional review action excludes actions based on any matter that does not relate to competence or professional conduct, and includes, but is not necessarily limited to, association with a professional society, fees or advertising, or engaging in other competitive acts, participation in any manner of delivering health services, whether on a fee-for-service or other basis, and association with a member or members of a particular class of healthcare practitioner or professional. That was a lot of slides in talking about the question on the difference between a professional review action and professional review activity. On those last few slides, we had adjudicated actions, we had medical claims, and we had professional review activity. Any Q's and A's on those?
Well, I think the stance on the adjudicated actions is pretty clear. If there's a settlement that doesn't end in liability, if the settlement results in a payment with respect to potentially a malpractice case, it's pretty clear that that would be reportable. If there is no other professional review activity taken as a result of that, it may be reportable as a settlement, but there's no professional review activity that's been taken, so that's not reportable.
Right.
On the other hand, if there's a settlement and there's no liability in the settlement, no financial liability in the settlement, but the physician is still the subject, or another healthcare practitioner is still the subject of an adverse peer review action independently, that would be looked at as a peer review activity, regardless of what the settlement says.
Right.
So I think that's pretty clear to at least to me.
Why is he looking at me?
I'm looking at you because it's your turn for the next question. Because I have further questions on this professional review activity issue, but that comes at the end of this.
I'm looking meaningfully at you now, Bill. Okay.
We're just a little bit out of order, but I wanted to back up and just make a point about the written complaint issue. What I understand from talking with a lot of colleagues over the past 6 or 8 months is that there is a sense that the use of the phrase "any form of writing" it signals a more expansive conception of what we've always all agreed to. There's no question whatsoever, never has been, that any kind of legal process that's initiated and filed that includes a demand, clearly that's reported. No question about that. Where pre-litigation proceedings are in place under state law and demands have been filed in that, those, again, there's no question about that. Those are parts of formal processes. What's been sometimes troubling is how informal is informal. Is something that is very informal and unfiled. It's not related to the initiation of a process recognized under law. It's not part of a process recognized under law. There is no court or no system that has any ability to enforce anything. It's patient says to physician or to hospital or to whomever.
In writing.
Well, not necessarily, and therein lies the fairly often it might be a phone call initially. Someone will call the hospital's risk management office and say, I had a really bad experience and I want you to pay my medical bills. That's not an uncommon occurrence. They might send a letter that says, I had a bad experience, please pay my medical bills. But that has nothing to do with, and it's completely outside of any formal process that has any enforcement capacity at all. If something is worked out there, it's purely voluntary. And so if the writing requirement is the real key, any form of writing, and in the modern age, that gets a little bit more complex. Those who have something like my chart with their healthcare provider, if they send an email to their healthcare provider that says, boy, this didn't go well and I had to have so-and-so, can you pay my bill? Is that a form of writing? And if so, how is that different from that same conversation should it happen in the real world rather than the virtual world? as a legal and practical matter, our clients are struggling with why there's any difference in someone coming into your office and saying, things didn't go well, can you pay the bill, as opposed to sending you an email and saying, things didn't go well, can you pay the bill? That distinction between the virtual and the real is more and more common now, and in fact, we encourage it. And as part of encouraging that sort of electronic dialogue between providers and patients, have we somehow complicated this process? And does that constitute a writing? And if so, why is that any different from saying it in person? Anyway, that's something that I think has troubled people as they've thought through this, and with the perception that there's a more expansive look at what any form of writing, as if we're saying, okay, whatever it is, even if it's the equivalent of a conversation with someone, it now has to be reported. So for whatever that's worth, that's an observation.
Can I ask a follow-up question?
Oh, please.
In the circumstance where someone emails, doesn't call, but emails their department, says, an example you're giving says, I paid for my medical bill if this happened. Does the hospital consider those payments to be made on behalf of the practitioner when they are made, or are they made from sort of, because our requirement is that the payment is made on behalf of the practitioner. When it's this sort of informal process, is that what you're still finding, that payments are made on behalf of a certain practitioner, can be linked to a practitioner's liability insurance versus a sort of umbrella insurance? I mean, I'm probably not describing the terms correctly. But
no, I do think I understand your question. And the answer is, to quote you, it depends. Patients often don't know where to go with a complaint. And so sometimes the hospital will get a complaint from an individual who's unhappy with something that was done by a physician who is simply an independent physician with privileges at the hospital. And so there it wouldn't really fall to the hospital to address that, and that would be dealt with in some manner by forwarding it to the physician. It may be that the individual is unhappy with someone who was a hospital employee or with something that happened that wasn't related to the physician's services. And in that case, that would be treated differently. So it really does depend on the circumstances.
And I sort of bring that up to just the requirement that we have that a practitioner is identified in both the written claim and the settlement, and that the payment is, or adjudication, and it's made on behalf of that practitioner. I think that might catch some of these concerns, if I'm understanding the concerns correctly, that while it's expensive to include any written form, then that's just step one to figure out if the resulting payment is reportable.
Right. Let me just follow up on that point, though, because I can see another little distinction, and I want to add something to his question and then come back to that. So one distinction is some hospitals have people who are not in risk management, but they are like patient advocates. So if things start to go awry, then they say, I'm going to send this person to you, and if anything else happens, then you can talk to them. And at that point in time, let's say that maybe the patient's still in the hospital or something has gone awry, but no one has disclosed or said to the patient that things are bad, but the patient is, or their family or somebody is like, something doesn't look right here. I think the way the regs are written as you have described them makes you have to forecast the decision, and you're as opposed to like in the preliminary stage as the hospital is working with patients and things like that. I think that's the issue that he's raising as a concern. Because if you have a two-part trigger and the second part is the actual filing, the hospital is in kind of like a little quandary about what they're doing in the midst of trying to resolve this issue. So that's, I think, a piece of the equation that needs to be discussed and thought about, and how it discourages possibly settlement, and it also, I think, impacts patient relations and quality issues and how hospitals internally structure things.
So this is actually $1 million question for us. We are in the thick of things as here at the agency, at the department level, trying to get smart and to do the right thing as it relates to medical malpractice reform and refining our guidance. And so I say all that to say that this is a question that we want to take our time with and we want to provide some informed guidance. We want to help being smart. We in turn can be smart in what we share to you. So I kind of hesitate for us to weigh in right now because it would seem irresponsible, frankly, to just be really quick in our answer. And so I invite you to continue to be part of this discussion with us so that we can do well by our guidance to you.
Mike, you want to go ahead with your question?
Yes, thank you, Michael. I have, and I acknowledge the issue of trying to define the responsibilities in this professional review area because of the difficulties in the definition. I mean, Congress has actually used two defined terms to define one further term. You know, professional review action is defined as an action that's recommended by a professional review body, which is a defined term, made in conduct of a professional review activity, which is a defined term. And a professional review body is defined as a healthcare entity, and that's, you know, further defined as a hospital or an entity with a formal peer review process or a governing body or a committee of that healthcare entity. So there's a lot of these cascading definitions. And it comes up in the issue of this termination without cause question. And I think the first question is the data bank comfortable with the idea that a termination without cause, which has the effect of terminating membership because of the employment contract, and terminating privileges because this healthcare provider, physician or otherwise, is no longer employed, loses all of their privileges, but without cause. Legitimately, if this is a termination without cause, is everybody comfortable with the idea that that's not a reportable event?
And it does have to be based on competence or conduct. So I think the without cause, maybe there's a definition there that we're not. To me, the without cause implies that element is missing, but maybe that's a misunderstanding of the processes in the hospitals. For it to be reportable, you know, it does have to be an issue of professional conduct and competence.
And then if it's an issue of conduct and competence, one would assume that there would be some type of professional review activity involved in this. So, for example, a hospital may have a hospital and a medical staff and a subsidiary that's not a healthcare entity because it's not part of the medical staff and it's not a hospital and it's not providing care, but that's the entity that employs all the physicians and maybe the other healthcare providers. And that entity may decide this person's Dr. Cassidy just isn't worth keeping. We're not going to have an investigation. We're not going to bother any of this. We just don't want him anymore. You are terminated without cause. You may have a history of events that have irritated everybody, but nobody has actually ever investigated it. They just don't want to do it. You're fired. Is that a reportable event? It's termination without cause. It may have all this baggage that goes along with it, but it's a termination by an entity that is not a professional review body and it's not part of a professional review activity. I think most lawyers would conclude that's not reportable.
I think you're really speaking to what's historically been a bit of a loophole for this program, and that terminations are not reportable if they're not part of a professional review, if there's a professional review action. So if you're a hospital and you want to get rid of someone, but you want to protect them a little bit and not have them end up in the data bank, you can go that route. So I think your first question was, are we comfortable with that?
It may not even be that you're not trying to protect them. The hospital doesn't want a hearing and a peer review process and all of that either.
Right.
They just want it to be over with. There's been no investigation, so there's no foreshadowing of it might be a quality problem, or it might be, it might not be. Nobody's gone that far.
That also sounds like you're saying that also this could be the manner in which the business is constructed, right? That these health professionals are employed by an administrative, like Partners Healthcare, right? So they are not physicians, well, some are, but they are, that's like the structure, and then...
We have 5 minutes left.
Okay. Phew, saved by the bell.
No, you said you get 5 minutes left.
We have 5 minutes left for questions. So if Mr. Callahan on the phone wanted to...
Right. Yeah, at the end I want to chime in when you all are done, so...
I wondered if you felt
I didn't mean to interrupt, I'm sorry.
Oh, that's
we've
fine.
gone
Don't worry.
astray, or was there anything?
I thought we had 10 minutes.
There's also 5 minutes for closing, so to wrap everything up.
Oh, the closing comments, okay.
Whether it will take that long.
Acted like a lawyer, lobbying. Should have reserved it for rebuttal.
Just to bring it all back around to, your question of, if it's an employment action and the hospital states that it isn't a professional review action, it hasn't gone through peer review, would the data bank have a problem with that not being reported? And I think, generally, the answer is no, because we require professional review actions to be reported. And I think even in the guidebook, I can't remember where the questions are, but there are some questions about the distinction between an employment action versus a peer-reviewed action. And if the hospital states that this was an employment action and there was no professional review action, I don't think the data bank would have a problem with that not being reported.
So consistent with the law, but sometimes doesn't exactly pass the sniff test, right? If Judy used the word you've happened upon and just not recently, a little bit of a loophole, like a little tricky thing. And so so I'm really fortunate to work with a bunch of principled people and feel really strongly about, as you all do as well, patient safety. And so it concerns us that there are some opportunities to skirt some things that would, so while our statute regs don't prohibit it, you're not breaking law, but you're not.
Well, but here's what's happening across the country, and I think Michael talked about it, is that if I was an independent physician, I have medical staff, bylaw rights, peer review rights, and as I'll discuss in a couple of minutes, a whole multi-tiered approach, which is fair, and that's appropriate, and that's been hot-wired into bylaws and policies. But the reality is, as you know, hospitals, either directly or through other corporations, are employing more and more physicians. And so in some sense, the independent doctor who gets this multi-tiered process leading up to ultimately a hearing, if it goes that way, again, those are rights that they have. In employment, it's employment at will. If Dr. Cassidy is showing some signs that, he's not playing well in the sandbox, or maybe the quality is okay but not great because they have higher expectations for employed physicians. But, if he was independent, he'd still be on the staff. He may not even be investigated or anything like that. But if they can cut the cord more easily with a doctor where there are some issues of behavioral quality, the reality is that's what's happened, and typically without any type of review. And I will tell you right now, no one reports those individuals, but nor have they been vetted or gone through a process to really figure out, gosh, does Cassidy really have a problem, or we just don't want to deal with them anymore. Because they don't get the same process, right or wrong, and it depends on the contract. That's kind of the reality. And yes, might there be some people that slip through the cracks? Obviously people have to respond to outside inquiries when Cassidy goes on someplace else. It's not going to be a perfect system, but, I think that is what's going on. Where there is a process, clearly they've baked into the agreement professional review action or some type of process. That's an altogether different situation, but at this point, not required. So, and I probably took up the few minutes we had, but if I can just make an overall comment and then we can do our closing. I was waxing poetic on the issue of proctor when I realized I put on the mute button, so nobody heard me. So. and maybe it wasn't so poetic, and that was just self-censoring myself. So. But I think what's important is all of this has to be put in context. And Erna, you kind of said this. Under healthcare reform, okay, everyone is paying based on quality outcomes, not based on volume. As soon as the physician steps in that hospital, anything he or she does is being monitored, okay? Utilization, outcomes, compliance with standards, be they departmental, section, or otherwise. So there's constant collection of activity to make sure that it's not just a quality or liability issue. Now it's a reimbursement issue. So the kinds of information that's being collected and gathered and reviewed is becoming exponentially greater, and it's only going to increase. And so the whole goal of the industry is, okay, fine, let's get this information, let's get back to the practitioner, let's try to figure out what's going on. And so you have this multi-tiered, what we like to call peer review process, starting with legal intervention. Here are your quarterly reports. Let's sit down. Let's talk about it. Let's see what we can do to get you back on track if there's an issue. We have monitoring. We have proctoring. We have all these other remedial measures well ahead of any anticipation or expectation that we have to take away someone's privileges or restrict them or take some action that's reportable. That's expensive. It leads to litigation, and it's not where we want to go. And so to the industry's credit, we've been doing more and more to be proactive, to be open, to adopt just culture, to get people to acknowledge that there are issues so we can deal with it. And it's only when those multi-levels fail, okay, and we've tried everything, which may be in the form of the FPPE program being the last step before a request for corrective action, that we need those mechanisms. We need those opportunities to work with physicians. Because if we start, ratcheting back and drawing lines that say, well, gee, you're starting to collect information on Callahan because he spiked some higher incidence of post-op infections. And yeah, we're looking at Callahan. That's what we're supposed to do. But no one's talking about taking away privileges. And on the issue of proctoring is one of those tools. So to say somebody being in the room or not being in the room somehow triggers a distinction as far as what's a restriction that's reportable really doesn't make any sense. How else can you observe somebody? Because what's going to happen is they're not going to do proctoring, okay, which is now taking away an important tool, or they're going to play games with it. Okay, we'll only proctor every other one where somebody's in the room. And that doesn't make sense at all. No one's restricting privileges. When that person admits somebody, there's a proctor. Okay, we have it for a period of time. No one's intervening. No one can intervene. If during a proctorship they're saying, hey, Callahan really has problems, now we have to up it to say mandatory consultation requiring prior approval, hey, we've crossed the bar. That's a reportable event. That triggers an investigation, if not a hearing. So, we should be looking for ways to empower hospitals and medical staff to work with each other and be flexible. And I heard, fair degree of flexibility here, getting into the issue of, what's a peer review activity, peer review action, how does a hospital determine whether there's investigation, and that's encouraging. But I just wanted to give that review because we're all kind of trying to figure this out, all with the goal of improving care. And I think the data bank is part of that effort as well. We just be mindful not to be drawing lines that handcuff people, reduce the kinds of remedial efforts they can implement, all for a good cause. And yeah, it gets to a certain point where there's clearly an investigation. These other efforts have failed. Those, hospital medical staff can figure out what that is. But the three of us have been doing this for over 30 years. I know it looks like, given how they look, it's more like 40 years. I look like a lot younger than they do.
That's why you refuse to be here.
That's right. And you just look at my webpage picture, which is like 10 years old or so. But anyway, I just wanted to make that comment because I think that's what permeates all of the issues and concerns that we had, and I'm sure others in the industry have, who've been kind of in the trenches doing this on a day-by-day basis, all for good cause, all for trying to improve patient care, yet still, get the physicians to invest in the process. And if we, again, start drawing the line where, things are now an investigation, it's really going to undermine that effort. So enough of my soapbox comments. But
You've left me 1 minute. Wow.
that was by design. So
I think in that 1 minute, it's important for me to say that the ground that we have in common is about quality care and patient safety, and so for sure we're willing to stand shoulder to shoulder with you around that. Our obligation is to help you meet your obligations to report under the law. And to also say that we're self-aware. So we know that there are there's variability in what happens in places and how that impacts reporting, reporting more so than querying. While, our language says that, we retain the right to be the final arbiter, our desire is also to apply the reasonable person standard, right? And so is this reasonable in your setting? Is this, and to accept, definitions of reason, we're reasonable when we talk to you and expect that your processes appreciate that they are as well. I've ended all of our public outings and presentations with giving out my direct phone number. And so I see here that our PowerPoint slide does not include my direct phone number, but I will amend that as an expression of our commitment to work directly with you, to answer your questions specifically, to not run from the challenging, nuanced situations by giving you my direct phone number. And to keep my promise to return your call or have one of my colleagues return your call. So my direct phone number, not my personal phone number, my work number is 301-443-1891. The email with our policy email address is a good source for you. So that remains something that I encourage you to submit your questions using that address. And then just a great thank you to HLA for partnering and preparing today's agenda. We talked about you with charm and humor as we were preparing. I think we were charming, but it was a nice collaboration, and it was rich and high maintenance in some instances that hopefully contributed to a positive outcome. And finally, I'll just say that this is not an event. We will do this again and again and again as necessary. So thank you for being part of this with us.
Greatly appreciated, very much so. And I think our members will have found it to be, again, a rich and very informative process, and I think they will be hearing again and repeating the recording of this because it's been very useful. So thanks again, Robert, Mike, any closing comments? I have nothing else to say. We'll give you feedback, whatever feedback we get from our members, and if we can find out what the total tally, I'd be curious as to how many actually signed on. So again, thanks so much.
Thank you. Thanks. We're off. Is the operator